not that my notes reflect.
You're right. I didn't ask a review. I absolutely.
Well, no problem here. We again thank you both for your arguments this morning. The court will take this matter under advisement. We turn to the next case on this morning's docket. That is case number 101458, State of Kansas v. Christopher Lowrance. Before we begin oral arguments on this case, I just wanted to ensure that our guests are aware of the nature of the case that's coming up. Very well. Thank you. If you'd like to wait till they're out, or you can start now if you like.
May it please the court, Sarah Ellen Johnson of the Capitol Appellate Defender Office on behalf of Mr. Lowrance. And Your Honor, I would like to request 3 minutes.
3 minutes is granted.
As the court is undoubtedly aware, this case involved a brief remand to the district court for an evidentiary hearing on the first issue in this case, on the prosecutorial misconduct and closing argument. What happened is that this case was, to a large extent, a battle of experts on testimony surrounding the victim's injuries or lack thereof, not so much necessarily on the fact that the death was a homicide, but on other factors going into the circumstances of her death. And in closing argument, the prosecutor made great hay about the fact that our expert was some fancy $300 per hour expert, and he got what he needed for free. And of course, a couple weeks after the trial, the county attorney received the bill for the state's medical examiner, including bill for his time testifying and for the autopsy itself. So we had the remand to establish that it had just never occurred to the experienced trial prosecutor who was trying this case that there were costs associated with the autopsy, that we had to pay for that coroner's time in court and that we had to pay for the autopsy, which seems odd to me, how anyone could not understand that an expert who has gone through schooling and has those advanced degrees doesn't get compensated for their time in court. And so that's the issue, is that we had this false argument presented to the jury to say our expert shouldn't be believed because he's getting $300 an hour, but their expert, there's no costs involved in that. And given some of the specific differences between the two experts' testimony, I think this is really critical to have allowed the jury to have this sort of false sense that one expert had basis for being biased and the other expert didn't, when in fact they were both, as we would expect, being paid for their time and paid for their services.
Help me understand that harmlessness part of the analysis. And in terms of why were there any differences in how the experts finally ended up significant?
Well, keep in mind that we're talking about a capital murder case, so we have that extra added element of there being an attempted rape. This is where I think the bruising claim that the state's expert had on the legs is so critical.
So whether it was bruising or decomposition?
Decomposition, yes.
I'm having trouble getting the word out, yes.
That would go to the state's theory that her pants were removed by some force.
By force. As
opposed to she removing them herself. It certainly would seem logical if you vomit in the car seat where she was. It's possible that some of that could have gotten on her pants and she could have taken them off herself. So I think whether that's bruising on her legs or not is very significant to that overt act alleged towards the attempted rape. Also, there's the dispute about the liver laceration, which I think further goes to the question of, was this a brutal attack where she was hit in the abdomen so hard that she received a liver laceration, or was that an unfortunate post-death result of being unfortunately thrown from a bridge and landing 50 feet below, which was what our expert said was the more consistent finding, that there simply wasn't enough blood for that to have been pre-death. And so I think all of that goes to not necessarily the homicide itself, but the aggravating attempted rape element.
Is there any explanation or theory espoused by either the defense or the state about the one drop, basically, or the one spot of blood on the door jamb and how that might have happened? As I recall, that the forensic scientist only identifies blood in one location, and that's on the door jamb.
Inside the car?
Well, I don't know that I would say the door jamb was inside the car, but...
That I'm not recalling off the top of my head. There was the car seat that had the...
There was two spots on the car seat, but were those ever identified as blood?
Not exclusively, no. That preliminary test came up as blood, but of course that can result from a lot of things. And the defense theory on that was certainly that she had vomited in the car.
And I'm just trying to see if there's any tie from the pathologist's opinions to the blood. That would cause anything that either of the pathologists
I don't think either of them testified to anything, any obvious wounds from which she would have been bleeding. There's no testimony that she had, an open outside wound. The only bleeding was that internal liver laceration.
Okay.
So
we just have those two differences, the bruising and the liver laceration.
Yes, those are the main differences. And some more reluctance on the part of our expert to say for certain that the cause of death was definitively asphyxiation, although with the ligature tied around the neck, it's certainly a logical conclusion to draw. He was just a little less willing to say there wasn't some other bodily system that contributed to the cause of death. So those are the main differences.
Okay. Thank you.
And again, I would say if we're talking about a capital murder where we're relying on an overt act of this forceful removing of the pants, whether there was force involved in that liver laceration pre-death and whether there was bruising on the legs, to me is critical towards that element. That is all the presentation I have on that issue. I was planning on submitting the additional issues on the brief.
Any objection to counsel not filling her time? I see no questions. Thank you, counsel.
Thank you.
May it please the court, Chris Elsleger, appearing on behalf of the state. And certainly here in this case, the prosecutor did make a mistake in his characterization of the fees, but when you look at it in the context of the overall case, it was not a gross and flagrant error, nor was it motivated by ill will, and certainly it was harmless.
What was the motivation then? To point out that it's compensated other than to create some kind of bias against the credibility?
Well, this court has said over and over again that exposing a bias or motive for testifying is a proper subject for the prosecutor to comment on. Exposing the fees of an expert is proper. Where he made a mistake is his characterization of, he said, I got mine for free, which was an understandable mistake because, before this case, I had the same assumption. I thought
how can that be understandable?
Well, we thought he was a state employee.
Don't state employees get paid?
Yeah.
Did they think this coroner was a volunteer? I just don't understand how you can argue this was innocent or
I think what he meant was that it wasn't an extra cost. I mean, all of us get paid, although sometimes I think I work for free. But
sometimes it feels that way.
His point was that we weren't paying an extra $300 an hour for this guy. This is just a state employee. This is just a regular worker. Now he was wrong, and he admitted that in the remand hearing. But significantly, look at what he said. Though, look what his point was. His point wasn't that, hey, don't believe this other expert because he gets paid a lot of money. His point was it doesn't matter. They paid him a lot of money. We didn't pay our guy a lot of money, and they both came to the same conclusion. If you look at his statement, he said, He says, I got what I wanted for free because they're both saying ligature strangulation of a non-struggling victim. That was his point, was that the state's expert said, look, she was murdered. The cause of death was ligature strangulation, and there's no signs of a struggle because she was unconscious or what have you. The other expert, the defense expert, also on cross-examination, admitted that he could not rule that out. He admitted that could be the cause of death if the victim was not struggling. That could be the cause of death. And so his point was, it doesn't matter which expert you believe, whether you believe the high-priced one or the low-priced one, they both came to the same conclusion. And that was his point. And this discussion about the other injuries, to me, that's kind of a red herring, because that stuff didn't really factor into the crime. The crime was...
So why would this be an attack on this expert's credibility if that expert, according to the prosecutor, is saying the same thing as his witness?
Well, I think really it wasn't. I mean, what the prosecutor was trying to say is, look, this guy, this slick expert that's coming in for $300 an hour, he said a lot of things, but ultimately the bottom line is he can't rule out this cause of death, the same cause of death that our expert said. That was his point.
Well, I go back to, I think it was Justice Johnson's question. I'm having trouble understanding what the point was. If it's not credibility, and it doesn't seem necessary to point out how much that person's being paid versus nothing by the other expert.
Well, I mean, certainly it's just a matter of rhetoric. I mean, he's saying, look, they got this high-priced expert. We've got our rough around the edges expert. You know, they disagree on some things, but the ultimate conclusion is still the same. And I think that was his point, because you look at how he concluded that. He said, because they're both saying ligature strangulation on a non-struggling victim. That was his point, and then he moved on to something else. So what he was trying to point out to the jury was it really doesn't matter which one you believe. The ultimate issue here about how this girl was killed, both experts agree, or at least couldn't. The defense expert could not rule out that cause of death.
You understand the difficulty here is that you stood up and you said there was a mistake, a factual error, in terms of who was getting paid and who wasn't. Yeah. But it's okay. It's not ill will because the prosecutor's permitted to impugn the credibility of the witnesses by suggesting that they have a bias, which is true. We've said that lots of times. But then you said that wasn't what he was doing. He was. We're feeling a little whipsawed up here. Problem. What's your argument?
You have to. Well, first off, on a bigger basis, it's not improper to comment on how much a guy's getting paid. But ultimately, he wasn't.
Show bias. But then you're saying he wasn't trying to do that. It sounded like a kind of
I think he was actually trying to do a little bit of both.
Mr. Osler, it sounds kind of like a gratuitous, as I understand, 5 times in 6 pages of transcript dig on the way to demonstrating that they agreed. In which case, he's really trying to support the testimony of the opposing witness and saying, look, he doesn't really differ meaningfully from my witness.
I think the prosecutor was trying to do a little bit of both. I mean, he's making an argument to the jury to persuade them.
And then if he's just doing it as a gratuitous dig, why is that not ill will?
Well, I think he's trying to show that, hey, this guy's being paid a lot of money, and that's something you can consider in evaluating his credibility. But then, regardless of all that,
but you should believe him because you agree with my guy.
But regardless of all that, it really doesn't matter because they both came to the same conclusion. I mean, the prosecutor's trying to cover all his bases, I guess, is the best way to say it.
I think that's a fairer characterization of what was going on.
And that's what I'm trying to do.
The textbook example of what you say he was attempting to do or she was attempting to do was to say, here's our expert. The expert said X. And the defense expert, who's getting paid a lot of money for the opinion, said the same thing. So you have 2 opinions from 2 different experts saying the same thing, and one of them is a super expert because of all the money he or she got paid, therefore we move on. Isn't that the textbook example to do that? But it's the dig about $300 an hour that I think is troubling some of us.
That is the textbook way to do it, but let's be honest. I mean, this is a trial. This is a closing argument. I've never seen a textbook closing argument. I don't know what a textbook closing argument looks like. I mean, you got to understand, and you all know this. I mean, the prosecutor is speaking extemporaneously. He doesn't have a script. He may have some notes, but he's got some ideas, some concepts in his head, things he wants to get across to the jury. And sometimes all of us misspeak, and that's simply what he did here. But it certainly wasn't motivated by ill will. But I think when you look at the overall picture, though, it was ultimately harmless, because the ultimate point that he said was they're both saying ligature strangulation of a non-struggling victim. So he's basically saying, he's getting paid a lot of money, he's not getting paid much, but they both come to the ultimate conclusion is the same, and you really don't need to worry about all of the other little differences between their opinions. But in a way, he was trying to cover all of his bases. He was trying to point out that this expert that the other side brought in, he's paid a lot of money, and you can consider that in considering how much weight and credibility to give to his testimony. But ultimately, in the end, both experts can't rule out this cause of death, and that's why it's harmless.
Mr. Elslinger, we've had a number of these cases. I can't remember if you've argued any of them, but I know this has become kind of a frequent issue. And we've had some fairly close to the line cases where we had the 2+ prosecutor saying the expert basically would say 2 + 2 is 5, and we've had the $3,500. He's being paid $3,500 to say it was an accident, essentially, or $3,500 worth of reasons to say it was an accident. And I can think of several.
I can too.
Yeah, and I guess I am concerned because you seem to recognize that there's a pretty fine line there, and it seems like maybe the answer is that other than pointing out that an expert witness has been paid, there shouldn't be any further comment, such as they'll say 2 + 2 is 5, or they have $3,500 worth of reasons, or whatever, or comparisons to the fact that the state isn't paying their expert, assuming that were true. I'm saying, why is it that they can say anything other than, oh, by the way, their expert's being paid?
Well, I think the bright line is you can't say that this expert is being paid to lie. He's telling you whatever he wants to say, whatever they want him to say, because they're paying him to lie, essentially. That's the bright line.
Right. But it gets so close to that. Obviously that's the implication. It's without saying, oh, he's lying. How do you prevent that?
Well, I think you stick with that rule. But I think if you look at the case law, the cases where it's been upheld, I think it's certainly okay to tell the jury, this guy's getting paid a lot of money. Please, weigh that in your consideration.
Right.
And I think
that's not that hard to do, though, without
right.
making additional comments.
And the additional comment here, though, I think it is critical, is that he did not suggest that Dr. Young lied for a fee.
Right.
What he actually suggested was they're both saying the same thing.
Which is that's working against me this morning for whatever reason, because you're basically saying it doesn't matter that he's being paid $300 an hour, but I'm going to talk about it 5 or 6 extra times. And that gets back to the Chief's point of this is where you're digging, and at some point you guys got to stop, or you're going to cross the line and require a reversal. And I don't understand. And so when you get a case like this where you're admitting it doesn't matter that he's being paid $300, yet it keeps coming up.
Again, I would point out that the prosecutor in the first place was trying to cover all his bases, because in hindsight it's always easy to look back and say, well, you didn't need to say this or do that. But at that time he doesn't know that, so he can't get in he doesn't know what the jurors are thinking, so he's trying to cover all of his bases.
6 times? How many times do you run the bases when you're a runner? That's where I think you have to focus and talk about that the repetitiveness does not show ill will and malice on this one.
Well, I think that I think if you follow the case law, all prosecutors know that you're allowed to comment on the amount the guy's getting paid as it affects his bias or any potential bias, and it's something that the jury can figure. So prosecutors, knowing that, feel that that's fair game, that they can go there. And I don't think that there's ever been a case that says you can only mention it once or you can only mention it 3 times. There's never been any kind of case that says that. So how would a prosecutor? How would he know that that's a line that he's crossed? I don't think there was any objection at the time to point out that, hey, even the defense thought maybe he was crossing the line. There was no admonishment from the court to say, hey, you're going a little too far here. Why don't you stop? And I think that there's another piece of the harmless error analysis that I haven't got to yet. Let's just look at all the other evidence.
Yeah, would you please do that? I want to
Before you get to that, let's just talk about the pathologist. I want to get to the harmless error in this, but I want to get to that pathology. But go ahead and Just
No,
as
no,
reason
no.
to ask this
My
question.
question does have to do with the rest of the evidence. And what would you please review for me and maybe my colleagues? What evidence supports the attempted rape?
Well, we start with the party, and the fact was that Cole Osborne, the guy who had the party, he said she could stay there, she could spend the night, but the defendant was very insistent that, no, I'll take her home. I want to get, very insistent on getting her into his car. You have the other witness there, Ramsey Ottadell, who says, it looked to me like he wanted to get something. I mean, he wanted to have sex with this girl. He apparently, his conduct, his behavior was fairly obvious. Then he drives her out to this secluded part of the country, out 10 miles outside of town, fairly close to an area where he had previously taken a girlfriend to have sex.
And that was 4 or 5 years prior to this?
It was some years prior, but that's the evidence that he had been out to that location before for sex.
I don't want to move past that. Go ahead and answer the question there, but I don't want to move past
No, go ahead.
it.
I'm fine going.
Because we have the evidence that previously he would take his girlfriend to his favorite spot in the country, and she would voluntarily remove her pants and panties. He would come around to the passenger side door, and they would have sex. Here we have a victim that's found without her pants and panties, and why does this evidence make it more likely that he forcibly removed her panties when we have the blood on the door frame on the passenger side? If it were to follow what had happened before, it would contradict that he forcibly removed them. So, I mean, how can you say that's relevant to an attempt to rape by forcibly removing clothing?
It's relevant to an attempt. We didn't say he completed the rape. It's relevant to his intent in going out there. It's more evidence that he intended to have sex with her. And you also have to remember that she was so intoxicated.
He intended to have sex with her, but even if he didn't think it was consensual, why is driving the victim to your favorite place in the country, why is that an overt act rather than mere preparation? We have to draw that line. If you're merely preparing, then you haven't made an attempt. You have to do the overt act.
Well, I think the overt act, there's multiple steps here, but I think that is an overt act when you consider that she was so drunk that she could not have consented to sex. She was so drunk she couldn't even walk. And I think the coroner, his analysis showed her blood alcohol was like 0.188 or something like that. She could not consent. This didn't have to be a forcible rape. She was too drunk to consent to sex. Any sex with her would have been rape.
Was that an argument? Was that an argument made at trial that she was so drunk she's incapable? And were they instructed on that about the involuntary
inability to consent?
Right.
I don't know.
It's a good argument, but I don't recall seeing that was part of the elements of rape, that unconscious or incapable.
I mean,
of
certainly
giving
her blood alcohol content was brought up. It was brought up that she was too drunk to walk. Her level of intoxication was certainly presented to the jury.
Don't we have to infer, though, that he is the one that removed her pants? If she voluntarily removed her pants, what overt act did he take?
Again, I think it's the entire process of taking her out to the country. But I think again, because she was so drunk, I think you can infer that he removed her clothing. I don't think she was capable of removing her clothing. She was so drunk she could not even walk. And she was so drunk she couldn't struggle against somebody who tied a cord around her neck and strangled her. I mean, the coroner's testimony was she didn't struggle because she was so drunk she was almost essentially passed out. So she couldn't. I think a very reasonable, if you look at the evidence in light most favorable to the state, is when you look at the sufficiency of the evidence, a reasonable person easily could conclude.
I'm concerned, though, about how many inferences we're stacking. I think Ms. Johnson made that argument in her brief, that to get to the conclusion, you have to stack about 3 inferences.
I don't know that you have to stack 3 inferences. I think you can draw reasonable conclusions from this evidence that there's not a whole lot of other conclusions to draw. And I think the other thing you got to remember is look at the preposterousness of his story. I guess if I was sitting on the jury, I don't know that I would have any other choice to make but to find him guilty. His story was, I got her in the car, I drove her away, And at some point I blacked out, and some mysterious person came along to the car, opened the car door, removed her pants, strangled her, killed her, left me alone, left her there, shut the door and walked away or something. And so then I woke up and, well, there's a dead woman in my car. What do? Well, let's don't go to the police or go to the hospital. Let's just go drive out of town and dump her in the river. That is such a ridiculous story that I don't know that any other conclusion could be drawn from this evidence other than what the state presented.
I want to circle clear back to the question I had earlier. Why isn't the prosecutorial statement about the fee cause harm when we get to the attempted rape part and the bruising and the liver laceration, and how that may fit into evidence of force?
No, when I read this case, that stuff didn't even register in my head as part of the. I mean, I kind of was wondering, why are we even going into this, because that doesn't seem to be evidence of. I mean, I suppose the liver injury could be evidence of. I think maybe the theory was that when he tried to climb on top of her on the passenger side, that maybe he rammed her in the abdomen with his knee or something like that, or he punched her. But I don't know that that was. I don't know that that was actually, that argument was made at trial. To me, the evidence of the attempted rape was the first off, the evidence from the party and the observations of the people there that he was interested in getting sex. He was insistent on getting her in his car. She was so drunk she couldn't consent. She was so drunk she couldn't walk. He takes her out to the country where he has taken his girlfriend before to have sex, follows the same MO, removes the bottom half of her clothing, climbs the passenger seat. Something doesn't work out the way he plans, and then he decides he strangles her, and at that point he throws her into the river. I think that's where you get the attempted rape. I'm not sure that force that a whole lot of force was even necessary, because she was so drunk she couldn't really struggle. So I don't know that all of that other evidence was really all that relevant. I think what the prosecutor was saying when he was talking about the experts, he was getting back to the ligature strangulation, because that's what he closed with. He said, I got what I wanted for free because they're both saying ligature strangulation of a non-struggling victim. That was the context of his comment. The other discussion about the other injuries, I think, was sort of secondary or even tertiary to the fundamental issue here, which was, one, she was killed by strangulation. Somebody strangled her, and the circumstantial evidence presents that there was an attempted rape. And I don't know how far. Nobody knows how far he got in his attempt, other than he certainly got part of her clothing off, got her out to the woods. But he didn't perfect the rape, because there was we didn't find any DNA evidence or evidence of penetration or anything. So, does that answer your question, or?
Mr. Osler, the jury instructions are in the record, correct?
They should be.
The final ones. Well, I'm
Yeah.
asking because I really am curious about whether they were instructed on inability to consent as a method.
It has been so long since I reviewed the record. It's here in the court, so I don't recall now.
The fact that, as one person testified, that he was insistent that he be the one to take her from the home, is that, in your view, an overt act toward an attempted rape? And that then, in turn, is laid on top of the fact that he did not just take her home, but he took her to this place where he had consensual sex with a female a few years earlier?
Yes, in fact, he didn't take her home. I mean, he said he was, but he had a plan in his head all along that he was going to take her out to the woods and have sex with her.
Well, it's one thing for someone to have told him, why don't you take her home at the party? And he says, yes, I will. And before they get there, he takes her out to the country. My question is whether it is a separate overt act for him to be so insistent at the party that he's going to be the one to take her. And when they leave, then in addition to that, he takes her out to the country.
I certainly think so, because the person who had the party said she can stay here. Nobody said she needed to go anywhere. It was the defendant's idea that she needed to go somewhere, and it was his insistence that he be the one to take her that I think shows that he formed that intent right then and there before he left the party, and he took her away from the party with that intent, that he was going to I think he saw a vulnerable victim that he thought he could have sex with. And that was his intent the entire time. He had no intention of ever taking her home. He was going to take her out to the country and have sex with her, whether she liked it or not.
Thank you. Do we have any further questions of counsel?
Also, I read the forensic scientist, Krim Swanson, I think is her name. Testimony is very short. Didn't take very long at all. And I think that the prosecutor maybe failed to ask a critical question about those two blood stains, or those two stains on the seat, because I can't find anywhere where she identifies it, even in preliminary testing, as blood.
Well, I know there was, and it was cited in the brief, I think it was page 81.
Yeah.
There was a site where she said, I tested the stain, and it came out, it tested positive for blood.
That's the door jam. That's all I could find. But anyway, if you'll, and I'll review, I'm sure the court will be looking at that closely, but assuming with me that there isn't a direct question and statement that those two spots were tested as positive for blood, can you address the harmlessness of the other statement by the prosecutor about the vomit story not working? And why that would not be harmless if there is no evidence of the stains on the seat being blood?
I think, again, he probably, if that's the case, if the record bears out what you're saying, then I think he probably made the same mistake I did and thought that, he just conflated the stains. But again,
I'll tell you, the inference is there.
This is so secondary, though, because the story about the vomit thing was tied to his story that he went to a gas station with her to get something to drink after she vomited and clean up or something like that, and that then she got in a truck with some stranger and disappeared. Well, that was proven wrong by surveillance video from the convenience store. So the lie behind the vomit story was well established by other evidence. That the prosecutor's point was the vomit story isn't working. So he moves on to another. He makes another story up because that was his first story. And the prosecutor's saying, yeah, but the vomit story ain't working. So he moves on to something else. And really, the reason I'm not sure that the vomit story was totally undercut by that video. I'm not sure how much that little drop of blood really plays into that. So I think there, again, it's harmless because the ultimate point was this story was a lie, and it was proven to be a lie by other evidence besides what the prosecutor said.
Except isn't vomiting a plausible reason she might have removed her own clothes?
No, I don't think so. I've known a fair number of people who have vomited in their lives, and I've never known any of them to, in a public place, completely remove their clothing because they had vomit on it. And then, of course, she couldn't walk. So, because she was so drunk, I would be shocked that she could take her clothing off because she was so drunk. It
was the bottom half of her attire, wasn't it?
Yes, and of course, logic would dictate if you vomit out of your mouth, it's going to go down. If you're sitting in a car seat, it's going to be on the front part of your clothing and so forth. The vomit story just simply didn't hold a lot of water. And again, when you look at the overall evidence and you juxtapose that with his story of what happened, which is so unbelievable as to it's just ridiculous, I think that you would have to come to the conclusion that it's harmless.
So if the most believable scenario one can divine from the known facts would support conviction, that's meets the sufficiency of the evidence test?
Oh, well, certainly, because sufficiency of the evidence standard, you have to look at the evidence in the light most favorable to the state, and you have to resolve any conflicts in favor of the state. And certainly, in this case, the evidence is sufficient. If there are no further questions, I would simply ask the court to affirm the lower court.
Any further questions, counsel? Thank you, counsel. Reserve 3 minutes for rebuttal.
Just to clarify a few points. First, and this is on page 46 of the volume that involves closing argument, the prosecutor's vomit storyline was separate from the BP Amoco gas station story not working, because immediately after the paragraph where he says the vomit story doesn't work, he then moves on to talking about how the BP Amoco story also doesn't work. So he was more focused on she didn't vomit in the car, even though we have other witnesses saying the car clearly smelled like somebody had thrown up in the car. And I would also note, Justice Beyer, that yes, they were instructed on intoxication.
Thank you.
And finally, I would suggest that if insisting on taking a drunk girl home is sufficient to establish an overt act towards attempted rape, I'm afraid that we have an awful lot of attempted rapes happening in every college town in the state every weekend. there has to be something more than he was really insistent on taking her home. That is simply too far removed to be an overt act to support a capital murder.
That's a little misleading, because it's not that he insisted on taking her home rather than let her drive. It was he insisted on taking her away when it was unnecessary. That there's a big difference there as to the meaning of the insistence.
I guess I would disagree that there's a huge difference there. But regardless of which one it is, simply insisting on giving a girl a ride, I'm leery of letting that be an overt act towards an attempted murder, especially in the context where, or an attempted rape where it's supporting a capital murder charge. I would respectfully ask that Mr. Lowrance's convictions be reversed and his case remanded for a new trial.
Any further questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. This time the court is in recess for 15 minutes.
All right.